Alrighty, this is our fifth and final section for this chapter, chapter 15, Environmental Dispute Resolution. And this is the fourth standard for settlement and is called credible take it or leave it offers. So settlement can happen if one party can extend a take it or leave it offer. And what take it or leave it means is strictly that. Here I'm giving you an offer and you can either take it or you can leave it. This happens in all kinds of negotiations. Real estate is one I know a little bit of. And if I extend a take it or leave it offer, there is no room for negotiation after that. No offers or counteroffers. Now, your book goes into, is this credible? In other words, is it in the best interest to be take it or leave it, as opposed to going to trial? And your book says it is dependent upon a party being able to make a credible offer. Now, and if a party had such power, assuming the parties were rational and seeking they maximize the expected value of their net gains, the person making the offer would make an offer slightly superior to the offeree's expected net outcome from trial. In order to avoid trial, let's say if the person is expecting $100,000, you make it $101,000 in order to avoid trial. Now there are two categories, one being the sincerity rule. And under this rule, either party may designate an offer as a sincerity offer. The person who gets the offer either accepts this legally enforced take it or leave it offer or rejects it, in which case the parties proceed to trial with no further opportunity to bargain, and the person making the offer will pay the offeree's reasonable post-offer fees. So the person making the offer had better make sure that the offeree is going to accept it. Okay. And then we have something called the final offer auction. And a final offer auction allows the two parties to bid for the right to make the final offer. Wow. The amount of the winning bid is granted to the party who lost in the bidding phase. If the final offer is rejected, the parties must proceed to trial with no further bargaining, and each side is responsible for its own attorney's fees. So in both of these cases, your book goes into a case of the Environmental Protection Agency versus MESCO, and I assume MESCO is a company that has a Superfund site. So take a look at those two cases, and if we go over this in class, I may use these two cases to explain, but it just would take me too long to try to explain the two cases. Okay, now we have, as opposed to going to trial, we have alternative dispute resolution. A neutral party can foster settlement as opposed to trial. So it's not just the two parties going at it. You have a third party that is going to help in the dispute resolution. And there are different forms of alternative dispute resolution, or ADR. One is called decisional ADR, and it's conventional arbitration, where you bring in a third party, and the third party is going to be ultimately the one that makes the decision. This oftentimes happens in unions, especially here in Hawaii. You pick that third party, and the offer is what's known as binding. So the third party is going to make a decision between the two offers, and that is binding. So there will be no strike that union can do, and there is a final offer arbitration that is given by the third party once the third party has heard both cases. Now we have facilitative ADR techniques. and this encounters mediation. One or more mediators work with the parties to help them come to a settlement. And the mediators help the parties to clarify their differences and to, in essence, mediate or come to a negotiated compromise. And then we finally have advisory ADR techniques, and this involves doing some kind of a mini trial and a summary jury trial in order to kind of mimic what would happen in trial, maybe as a means to get the two parties to agree to some kind of mediation and some kind of settlement as opposed to trial. Now they have some terms here. A mini trial provides litigants with a snapshot as to what might happen in a real trial. Summary jury trial is an abbreviated form of trial that provides litigants with an advisory verdict with guidance for the settlement negotiations. Neutral fact-finding, a neutral party undertakes an independent investigation of an contested factual matter, such as whether a road would endanger wildlife habitat. Now, all this is going on, shall we say, behind the scenes and not necessarily in trial. Okay, final slide is called Compatible Perspectives, Different Rules of Civil Procedure. And these are rules of civil procedure that can govern court proceedings. And this is a part of something that might be called civil justice reform. Fledgling attempts to apply new rules of civil procedures that lower demands or otherwise satisfy one of the four conditions for settlement. Now, the first one, as shown by figure 15-3, is called the American Rule. Here, the American Rule shifts court costs, excluding legal fees, to the losing party for all cases. And under this rule, each party pays its own attorney's fees, regardless of the outcome at trial. And this rule generally applies to litigation costs, even when supplemental rules governing attorney's fees are in effect. Our second one is the English Rule. And this rule places a greater burden on the losing party by shifting the payment of attorney's fees and not just court costs to the losing party. In the English Rule, the loser pays both court costs and attorney's fees for both sides. And this is I would think, a rather effective means to discourage frivolous lawsuits, because if you lose, you pay. Finally, we have Federal Rule of Procedure 68. Are intended to encourage parties in litigation to settle out of court. The typical settlement rule allows a party in litigation to formalize a settlement offer. If the opposing party refuses that offer and does not improve upon it on trial, the refusing party suffers a consequence, so may pay the court costs and such like that. And so that is our third rule here, and the plaintiff is going to pay both sides court costs. So it's a way to, again, mitigate lawsuits by having a particular settlement rule. And that, boys and girls, finishes our final, I believe, 5th section of this chapter.